In this case, the question is whether the Russian Federation had overall control over the DPR in 2014. The court judges that this was the case, for a number of reasons. A number of the then DPR leaders are Russian citizens. Some of them, furthermore, have a Russian military background.
Sommige leiders van de DPR hadden een nauwe band met de Russische.
For example, defenders Kirkin and Dubinsky. Some DPR leaders had very close ties with the Russian Federation. Tapped telephone calls often talk about getting in touch with high-level persons in the Russian Federation, which they refer to as Moscow, or even more specifically, the Kremlin. For example, Borodai, the DPR's Prime Minister, was in almost daily contact with Surkov from June to August 2014, when Surkov was a close advisor of Putin. According to Borodai, Surkov was our man in the Kremlin. There was also contact between DPR leaders and Surkov regarding several DPR ministerial appointments.
Defendants Girkin, Dubinsky and Kochenko are found guilty. The court qualifies the facts declared proven in their cases as two or more offences arising from the co-perpetration of intentionally and unlawfully causing an airplane to crash, although this was likely to endanger the lives of others and people being killed as a result of it, and the co-perpetration of murder committed multiple times, to wit 298 times. These are criminal offences for which the accused Girkin, Dubinsky and Kochenko are punishable.
In summary, the court holds the proven charges so severe and the consequences thereof so grave that it holds that only the highest possible prison sentence would be appropriate punishment in retaliation of what the accused did and what caused so much grief to so many victims and relatives. The court is aware that imposing these sentences cannot take away the pain and suffering, but does hope, now that today, exactly 8 years and 4 months after the disaster, clarity has been provided about who is to blame, this may offer some relief to the relatives. All of the above leads to the conclusion that the court imposes a lifelong prison sentence to Girkin, Dubinsky and Kochenko. In view of the proven charges, how severe they are, the imposed sentence and affront to the rule of law, the court orders imprisonment of the accused. The court acquits the accused Pulatov.
The court first examined whether each defendant in turn could be regarded as a co-perpetrator by making his own contribution to the deployment of the Buktalar, and whether this was sufficiently important and whether he worked consciously and closely with other persons. If that is not the case, then the court next assessed whether the defendant could nevertheless be held responsible for other persons' contribution to the deployment. This last concept is known as functional co-perpetrator. Kochenko had received orders from his hierarchical superior Dubinsky to transport, escort and guard the Buktalar as far as its final launch site near Pervomaisky. Kochenko obeyed these orders, which involved ordering his subordinates to carry the duties out. Later, he told Dubinsky that the Buktalar had been deployed successfully and was safe. In addition, he carried out the Buktalar's removal, again on Dubinsky's orders. The court sees Kochenko in a leadership position in essential actions contributing to the actual Buk missile launch. He was involved beforehand and also arranged the Buktalar's return to the Russian Federation, and these are substantial contribution to the Buktalar's eventual deployment at the launch site. Where Kochenko himself was involved in the actions, he did so in close and conscious cooperation with other persons involved, including the crew. Karchenko is therefore to be considered a co-perpetrator of both charges. Dubinsky was highly placed with the DPR, and in the night of the 16th and early morning of the 17th of July 2014, he initiated and organized transporting the book Taylor from the Russian Federation. On the 17th of July 2014, he was in charge of transporting the book Taylor to its launch site and guarding it. The execution of his instructions he left to his subordinates. He gave them their orders and was therefore in a position of authority as their superior. The court considers this to be of such fundamental importance to the committing of the crime that it can be qualified as co-perpetration.
At an operational level, Defendant Gherkin was the highest military leader of the DPR, meaning he had the final responsibility for the deployment of military means by and for the DPR. Intercepted phone conversations show that Gherkin was in regular contact with Moscow about materiel and getting concrete military support, including air defense systems and trained specialists, in order to keep eastern Ukraine. The only possible purpose of this was actually using those systems in combat for the DPR. That is what happened is clear from the file. Under the authority of Gherkin, as the highest military leader, a lot of combat took place in which people were killed or injured and in which material damage was done. Part of that was also shooting at planes and helicopters, which repeatedly led to crashes. Rather than condemning its use, he actively works to make the evidence disappear as soon as possible, in order to avert an outcry he was apparently expecting. That is why the court considers it proven lawfully and beyond doubt that Gherkin had control over the use and deployment of the book Taylor, and that he was one to accept that, including the consequences of that deployment. Gherkin therefore qualifies as a functional perpetrator of these offences committed in co-perpetration. With regards to him, this leads to the same conclusion as for Karchenko and Dubinsky, to wit, the principal charges under 102 for co-perpetration are considered to be proven lawfully and beyond doubt.
First and foremost, the court states that persons other than the accused may be reproached for the separatists deploying and using a BAC weapon system. Indeed, the weapon had to be provided to be deployed. The weapon had to be transported, guarded, and the actual deployment itself must have been planned and implemented. It is the view of the court that anyone who played a role in this bears moral responsibility, at least, for the consequences of the deployment of such a weapon. A weapon which, given its very nature, can cause the devastating result observed during the judicial inspection. That devastation, most importantly, led to the death of 298 people, men, women and children on board. In an instant, without warning, their lives and those of the loved ones seated next to them were cruelly ended.